Court records are meant to show how justice is delivered, but not every decision is spoken aloud. Some outcomes are shaped by testimony and procedure. Others are shaped by how events are written down once the room is empty. These are those cases. This is what happened before the gavel fell.
Daniel Reyes receives the transcript in a manila envelope. No explanation. No cover letter, just paper. The envelope is heavier than he expects. He turns it over once before opening it, as if weight might tell him something. It doesn't. Inside, the pages are clipped together, neat, numbered, official. The kind of document that assumes it will never be questioned. Daniel opens to the first page. Case caption. Jurisdiction. Parties listed cleanly. His name appears exactly where it should. That alone unsettles him. He reads the procedural history, dates, continuances, appearances, everything that happened, without saying what it did. At first, it feels familiar. This is his case. He turns the page. Testimony, he reads his own words, or something close to them, page 3. He slows. A sentence feels wrong. Not incorrect, just finished. Where he said, "I didn't know what she meant." The transcript reads, "The defendant admitted confusion." Admitted. Daniel reads the line again. Admitted. He remembers pausing before answering, choosing his words carefully. The pause is gone. The care is gone. He keeps reading. Emily's testimony. Her answers are there. But her hesitation is gone. Her uncertainty flattened. Each sentence reads certain, resolved. Daniel remembers her stopping mid-sentence, looking toward the bench. That moment does not exist here. He notices something else. Parentheticals. Witness appears emotional. No one said that out loud, but now it's permanent. He turns the page. Cross-examination, where he said, "I thought it was over." The transcript reads, "The defendant acknowledged the relationship ended." Relationship. Daniel stops. His hands remain steady. His chest does not. He checks the page number. He isn't even halfway through. He tells himself this is normal. This is how transcripts work. He keeps reading. Page 8. A footnote. Witness testimony establishes a pattern of emotional reliance. Daniel freezes. He flips backward, reads the testimony again. No one said that, but the sentence makes sense. Too much sense. He turns the page and stops. Centered at the top, court's findings. Daniel doesn't breathe. Findings. There has been no trial, no verdict. He reads. Based on testimony and procedural history, the court finds the defendant's behavior indicative of unresolved emotional dependency. Daniel feels something settle, not panic. Finality. This isn't testimony. This is interpretation. He understands the shift. The transcript isn't reflecting the case. It's finishing it. Daniel notices the formatting. He hadn't before. Margins wider than necessary, spacing consistent, intentional. He looks at the headers again. Uppercase, centered. Each one feels heavier than the last. He flips back to the beginning, reads the caption again. State versus Reyes. No middle initial, no context, just a name. He wonders how many other names have looked exactly like this. On exactly this page. Daniel turns to the appendix. He hadn't planned to, but it's there. Administrative notes, time stamps, clerk initials, no voices, no faces, just confirmation that the document exists. He reads a line twice. Filed and entered without objection. Without objection. Daniel thinks about that. He wasn't asked. He wasn't notified. But the absence of objection has already been recorded. He realizes something else. The transcript doesn't just summarize the hearing. It certifies agreement from everyone who didn't interrupt. He looks again at the page count, counts the staples. This document will outlive him. Long after testimony fades, after memories soften, after explanations stop working, this version will remain. Daniel closes the appendix. Slowly, he reads on. Where the judge said, "I have concerns," the transcript reads, "The court determined risk." Determined. The remaining pages read like a summary, not labeled as one, but written like one. The story is coherent, linear, inevitable. Later, Daniel sits across from his attorney. The table between them is bare. Daniel places the transcript down, slides it forward. "Tell me where this is wrong." The attorney does not touch it. It isn't wrong, they say. Daniel laughs once, stops. Then what is it? The attorney looks tired. Older than before, it's authoritative. Daniel waits. Once something is written like this, the attorney continues. This becomes the version courts rely on. Can we correct it? Only if there's a factual error. Daniel flips to the footnote. That sentence about emotional reliance. Who said that? No one. Then how is it here? That's inference. Inference of what? The attorney hesitates, then answers. Outcome. Daniel leans back. So this isn't a record. No. It's a foundation. Daniel understands. This transcript doesn't document the case. It justifies what comes next. Is this appealable? The attorney shakes their head. Tone isn't appealable. Emphasis isn't appealable. What wasn't said isn't appealable. Daniel looks down. So this is it. The attorney doesn't answer. Later, alone, Daniel reads it again. He realizes something worse. This version of him is calm, measured, reasonable. That's why it works. The record doesn't portray him as guilty. It portrays him as explainable. And explainable people don't need trials. The last line stops him. Custody remains appropriate. Appropriate. Daniel closes the folder. The case didn't end with a ruling. It ended with a narrative. And once the story was written down, there was nothing left for him to say. The paperwork will show that Daniel Reyes received the official transcript on a specific date. It will not show the moment he realized. The case was already over. That happened halfway through the document, before the gavel fell.